We're going to continue on talking about the judiciary, and specifically we want to focus in on the judicial decision-making process of the Supreme Court. How do they come to the opinions that they have? And then what are the different political aspects of the federal judiciary? What's the politics involved? Okay. Everything in Part 1 can be found already online under Part 1A and 1B in the lectures. All right. This is just a repeat to know, to think about who are making these opinions. Remember, it's the Supreme Court opinions that we're talking about here. It's the court of last resort. And remember, they're primarily an appellate jurisdiction. That is, they hear appeals from the appellate districts, the appellate courts, the district courts, and usually the highest state courts. They do have original jurisdiction. Refer back to that slide from Lecture 1A. And there's a Chief Justice and 8 associates. So we've already recognized that this is John Roberts on the left, who is currently the Chief Justice of the Supreme Court. But here is a listing of everyone else in order of the seniority. And in terms of the seniority, that is based on when they were appointed, not specifically their age. But Antonin Scalia was born in '36. Before he became a federal judge, a Supreme Court justice, he was a law professor and federal judge. And you can see that he was appointed by Reagan in 1986. So he has been on the bench for a long time. Okay, obviously Reagan is no longer alive. Reagan also appointed Anthony Kennedy, who was born in the same year, and he appointed him in 1988. So Reagan, even though he has been out of office for 20-odd years, 24 years now, his legacy lives on in the appointment of Scalia and Kennedy. Clarence Thomas was appointed by George Herbert Walker Bush in 1991. Remember, George Bush, 41, was only president for one term, and so he only had one judge that he was able to appoint. Clinton was able to appoint 2 justices, Ruth Bader Ginsburg, who was appointed in '93, and Stephen Breyer, who was appointed in '94. So this is the second woman to be appointed to the Supreme Court, Ruth Bader Ginsburg. Sandra Day O'Connor was the first woman. George W. Bush appointed Chief Justice Roberts in 2005, and then Alito in 2006. And this is Alito over here on the left, on the right. And then most recently, President Obama was able to appoint Sonia Sotomayor in 2009. And then the last slide I showed you Elena Kagan, who was appointed by Obama in 2010. So this is a current makeup of the U.S. Supreme Court. 9 justices, 1 Chief Justice, and 3 women currently on the Supreme Court. All right, again, this is a repeat just to tell you again how many appeals are made, and obviously the court has to decide which cases to hear, and they hear about 1% of those, a little less than 1%, about 80 cases, 90 cases a year. Okay, so once they hear the case, they hear the arguments, they've had their clerks do the research, then they have to decide about the merits of the case and the opinions that they're going to have. So the Supreme Court normally hands down its decisions on Monday when they're in session. It usually issues a written opinion, and the opinion of the court is written by someone who's assigned by the Chief Justice, and it's usually the most senior member of the majority. So there's a difference between what a decision is and what an opinion is. So I want to define those for you right now. The decision indicates which party the justice sided with. It gives you the voting margin. So the decision is a 5-4 decision, or it's a 9-0 decision, or a 6-3 decision. Okay, so the decisions of the Supreme Court do not have to be unanimous. So the decision simply gives you the winner and loser. Okay, the opinion explains the reason for the decision. Okay, and so there's different types of opinions. There's the majority opinion, a concurring opinion, and a dissenting opinion. The majority opinion is a decision of the Supreme Court that represents the agreed-upon compromise judgment of all the justices in the majority. So if you have a 5-4 decision, those justices, those 5 justices who decided in the majority, are going to get together and someone is going to write the majority opinion and write it such a way that includes all the different judgment of the justices in the majority. Okay. That's called the majority opinion, and again, it's usually written by the most senior member of that majority. So if the majority is 5-4, of those 5, who's the most senior, they'll usually write the opinion. Or the Supreme Court Chief Justice will decide who writes the opinion. Okay. If the decision was 9-0, then the most senior member of those 9 obviously would write the decision. You can also have a concurring opinion. And a concurring opinion is written from one of the majority because they agree with the decision, but they might disagree with the reasoning. So they're going to write a concurring opinion to accompany the majority opinion. And then sometimes you have a dissenting opinion. In the 5-4 decision, those 4 who dissented have an opinion as to why they decided differently about the merits of the case. And so they'll write the opinion that disagrees with both the decision and the majority reasoning for that decision. Okay. So those are all called opinions. You have a decision which gives you the vote, 5-4, 6-3, 7-2. And then you have the reason for the vote, and that's called the opinion, and there's different types of opinions. Okay. Well, judges come to these opinions and these decisions based on a variety of things. And one of the things that we base our laws on are precedent. Okay? And so precedent, not president, make sure you spell this correctly, are simply referring to prior cases. Okay? And so these are a couple of cartoons, and the lawyer saying, as precedent, that means as prior cases, I offer the entire legal history of Western civilization. So he's making a point about technology. And here is the chicken, the proverbial chicken and the egg. And so you have someone on trial, and he says, Henrietta finds herself embroiled in a nasty and precedent-setting custody battle. Okay, does this egg belong to the chicken or the farmer? Okay, and so precedent means it's setting a standard. It's a prior case. Okay, and we base our law on precedent. Thus, the court is cautious about overturning the rulings of earlier courts. An example of this is obviously Roe v. Wade. While today's court might have a different view of this case, they have not ruled against Roe v. Wade. So Roe v. Wade has set the precedent for abortion in this country. We talked before about the case during the Civil War, right up to the Civil War, the Dred Scott case. Okay. We also talked about the Plessy v. Ferguson case. Other cases will come along that will reverse that precedent and establish a new precedent, and we'll see a lot of that coming up. So the Plessy v. Ferguson case was a case that established separate but equal. The Brown versus the Board of Education reversed that case and set a new precedent that separate is not equal. And we'll cover that case when we talk about civil rights and civil liberties. Okay. So the primary function of the Supreme Court is to establish legal precedent, which then guides lower court rulings and future rulings. The lower courts will then use what is called stare decisis in their rulings. Okay? So this simply means that they're going to let the decision stand. Okay? So when judges use precedent to decide a case, they are applying the doctrine of stare decisis. That means let the decision stand. Okay? It's the doctrine that a previous decision by a court applies as a precedent in similar cases until that decision is overruled. Okay. So these two things are used in concert. Precedent means a new standard is set. Future courts will rule in a case of stare decisis, meaning we're going to let the previous decision stand because it set a precedent that we agree with. Okay. So those are two terms you'll hear quite a bit when you hear about the opinions of the court. Okay. All right. That was a short introduction, but that's where we're going to stop for the first half and then get back into the politics of the judiciary in the second half.